The Judicial Conduct Tribunal has been postponed to the 30th of June 2025. Now, this comes after the body ruled that gender expert Lisa Vetten should be allowed to testify before the landmark probe on sexual harassment against top judge of the Eastern Cape Division of the High Court, Judge President Selby Mbenenge. This comes after evidence leader advocate Salome Scheepers indicated on Monday, the 12th of May, that she's not ready to close her case and that it's in the interests of justice to call the gender expert, a request Judge President Mbenenge's counsel objected to. The tribunal, in its ruling, however, found that Vetten should be allowed to testify the probe. The tribunal stated that it would rather err on the side of caution and allow the evidence. Now, in light of the ruling and the unavailability of other witnesses, the tribunal has been postponed. Chairperson of the tribunal, retired Judge President Bernard Ngwepe, delivered the ruling today.
One aspect on which there's been some disagreement is whether or not she should be allowed to come and testify at all, whether today or tomorrow or June or whatever. And the parties could not agree on that one, and we are here to give a ruling on that aspect as well. One of the arguments raised by Advocate Sikakane was the issue of relevance of the evidence by the expert and its materiality perhaps to the matter at hand. But on the other hand, there has been some counter-argument to say that the evidence is relevant and material. So, having considered the matter properly, we are the view that we should rather err on the side of caution, rather allow evidence, even though there is argument about its relevance, allow it nevertheless to be given. We allow it to be given because we are confident that if it is irrelevant, we'll be able to hold accordingly at any time, even at the end of that particular evidence. We will say it is irrelevant and then we will put it aside. Contrast that with a situation where you exclude evidence which might well be relevant and material. We think that in that case, we would have erred. So like I said, we want to err on the side of caution. Our resolve is that we should allow her to give evidence. And as I've said, if it turns out to be irrelevant, we are competent, I believe, to deal with it. And there will be no prejudice to anybody. For these reasons, we conclude that she should be allowed to testify, subject to the guidance that the tribunal gave some weeks ago, a week ago, and again yesterday, and again this morning. That being said, therefore, the ruling is that she will be allowed to testify.